So anyway, you're going to be the only one arguing here this morning. So you have 15 minutes, and the case we're hearing is N. Ray AM, and that is our 30215. You ready to proceed?
Yes, can everyone hear me all right?
Yes, thank you.
Okay, yes, Your Honors, I'm ready to go then.
Okay.
It please the court. Latasha Moore was under a cloud of suspicion from the moment she arrived at the hospital.
Counsel, I'm sorry, I was too lax here this morning. I apologize for interrupting you, but since we're not having both sides, I didn't even go through the admonitions. We are having this videotape for YouTube, as well as just our normal court policy says don't mention the names of the children. So I want to make sure you don't mention the children's names. Okay.
Okay, I did not. That was my...
Oh yeah, you didn't. I know you didn't, but I just wanted to remind you. Thank you. Now you can begin again. Thank you.
Okay. So the mother, Latasha Moore, was under a cloud of suspicion from the moment she arrived at the hospital. A decade ago, she'd had her rights to two older children terminated. Within a few days, this child, AM, was also taken for Miss Moore on the basis of a complaint alleging, in substance, that Miss Moore, but not the child, had tested positive for marijuana, and that Miss Moore was acting strangely in the hours after giving birth. 2 years later, all witnesses agree that Miss Moore and her child love each other and are exceptionally bonded. All agree that Miss Moore has an appropriate home, sufficient financial resources, and appropriate parenting skills. Nonetheless, Summit County Children's Services was awarded permanent custody, principally on the basis of Miss Moore continuing to test positive for cocaine and alcohol, with no evidence that Miss Moore's substance use posed any detriment to the child. Miss Moore now appeals for her child to be returned to his mother's care. There are no questions at the moment. I would like to address the second assignment of error first. I think that one really goes to the heart of this case.
That's fine. Thank you.
Thank you, Your Honor. Before permanent custody can be awarded to an agency on the basis of a mother's or parent's alleged mental health condition or substance use, some findings should be required as a matter of law that a parent's substance use or the mental health condition has or will have a detrimental impact on the child if should the child be returned to the parent's custody. This proposed rule is supported in the first instance by this district's case law, which is well settled at an earlier stage of proceedings for when a child is alleged to be dependent. Prototypical case in this vein is, of course, in BR from 2008, where the mother testing, very much like in this case, the mother, but not the child, tested positive for marijuana at child's birth. This court ruled that was not sufficient to adjudicate the child dependent in the face of evidence that the mother could provide an adequate home, and there was no evidence that supporting an adjudication of dependency. This rule has been extended to so-called hard drugs in a number of cases, including Henry CS from 2012. Also, there's a very recent 2021 case from the 12th District, Henry AV. It's also noteworthy that a condition of alcoholism or alcohol abuse, in the court's words, in the 2011 case of Henry OH, was not allowed to substitute for a finding of detrimental impact. So
let me interrupt you because I wasn't sure I completely understood the argument in reading the briefs. You're saying, obviously, in the second assignment of error, I know that there has to be a detrimental impact because of the substance abuse. However, isn't that more of an adjudication type issue because the child was adjudicated dependent? So, therefore, courts already found that it detrimentally affected her environment.
Well, I'm not at all clear in
Go ahead, I'm sorry.
Particular, I'm sorry.
No, I said her and it should be his. I apologize.
Oh, of course. I'm not at all clear that that's been found in this particular case. I mean, my client did waive adjudication here, so the child was found dependent for that reason. The complaint here was rather non-specific. It said that the mother tested positive for marijuana and that in substance she was acting kind of loopy after she gave birth. She thought she could hear her child crying when the child was on a different floor, so she probably couldn't if she had some difficulty with the medical staff's instructions about like keeping the incubator closed and things like that. I mean, there was even, I mean, she has, of course, stipulated to the adjudications that's not an appeal, but there wasn't, there wasn't an allegation that it was marijuana, which made her unable to understand that, whether it was marijuana, mental health, whatever. They didn't say what caused that. They didn't, I don't, she may have been in need of additional education at that time. She may have been in need of additional housing at that time. I mean, to me, obviously as an attorney reading that complaint, it really wasn't clear what the underlying conditions were exactly.
Wasn't the child also tested and found marijuana presence?
No, Your Honor, and I do appreciate that question. That was stated at one point in the judgment entry. However, that just doesn't appear to be correct. And looking right here at
Counsel, when you turn away, it's hard to hear you. I'm sorry.
oh, I'm sorry.
That's okay.
Well, I'm right here.
Now I can't hear you at all. Can you turn up your volume a little bit? Now we're not hearing you at all. No. Oh, shoot. No. Can you hear us? We can't hear you. Maybe you can you do it without your headsets, maybe? I don't know if that affects it, but no.
No.
Now I can hear you. Now we can hear you fine.
Earlier it was working only with the headset, so.
Oh, okay. I understand. This is what the problem with technology is. Go ahead.
Yes. So it does say that the judgment entry at the case plan, I mean, page 21D of the docket, it says that there's the case plan. It just says Miss Moore tested positive for marijuana at the birth of her child. The complaint just says Miss Moore tested positive. The state briefs don't mention anything about the child being tested. So I don't know where that came from in the judgment entry. The state never alleged that I can find. So that seems to have just been a mistake.
Okay, thank you.
And if that was an evidence, then they would have also presumably adjudicated the child abused, which he was not. They did check the boxes for abused in the initial complaint, but the abused allegation was dismissed at the very first hearing, the allegation of abuse. So I can only presume that the child was not tested.
Okay, thank you.
Okay, yeah, of course, no, it's an important point to clear up. I think we would have a different case if the child was tested. There's that case law at the point that of a dependency adjudication. I think the issues are analogous here, that those cases go to the purpose of a dependence of the whole statutory scheme. It's the constitutional rights involved. Clearly, there's some federal case law you can look at that states that William versus Walcott, in particular, 1978 U.S. Supreme Court case that stated we shouldn't separate parents and children without some showing of unfitness, as has been quoted in, I believe, several Ohio cases. The statutory purpose, the very first section of the relevant chapter. So that's Revised Code 2151.01 says that the chapter is to be interpreted to provide for the care of children whenever possible in a family environment, separating children from the child's parents only when necessary for the child's welfare or in the interests of public safety. The statute itself also clearly evinces the General Assembly's intent to require some finding of detrimental impact at the permanent custody stage. 2151.414E2, which was alleged by the state, the court below did not find it, requires a detrimental impact. It states the General Assembly's intent for the standard for when in permanent custody is based on a parent's substance use. I quote, chronic mental illness, chronic emotional illness, intellectual disability, physical disability, or chemical dependency of a parent that is so severe that it makes the parent unable to provide an adequate permanent home for the child at the present time and as anticipated within 1 year after the court holds the hearing. The General Assembly cannot have intended the E1, which is the only section the court below found besides E15, I believe it's E11, which essentially shifted the burden to Ms. Moore because of her previous terminations. The General Assembly cannot have found intended E1 to operate as and run around the requirement of detrimental impact inherent in the language of E2. And I will note, of course, that the state brings up that Ms. Moore was required to comply with her case plan, which said that she should have treatment for her substance use and not use substances, which of course she was. The case plan was a court order, and a parent who does not comply can be punished for contempt. She's not punished by losing her child. Case plan compliance or non-compliance is not even explicitly a factor anywhere in the section. That's 0.414. I would quote to Henry CM, a 2003 case where this court criticized, quote, a growing trend where the Children's Services Agency focused its evidence almost exclusively on whether the parent had complied with the requirements of her case plan, and stated that although the parent had not complied, what was then called CSB failed to present clear and convincing evidence that permanent custody was in the child's best interest. Leaving that, in the final way, then, since the substance use should not count against the mother when there's no showing of detrimental impact, all we really have left against her is the speculation that the boyfriend with the conviction 10 years ago might have some kind of bad effect on the child, and that this allegation that she didn't understand the child's medical needs. And if the state were here, I'd challenge the state to point out one specific to that allegation, one thing that she allegedly doesn't understand. She described the medical needs with reasonable specificity in her own testimony. She's stated emphatically that she would continue to get the child's treatment. We really just have this impression by the witnesses that she doesn't understand. They'd be afraid, almost stereotyping, it seems like. On the mom's side, she has and testimony of several witnesses, she has a suitable home, the ability to provide for her child. These are testified to by both of the caseworkers from the state who worked in this and by the guardian ad litem. She's a loving relationship. She's fully devoted to the child, who is in turn loves his mom and knows who she is. And any problems with her parenting were very minor, such as giving him, I think the one caseworker said he was given too many sugary drinks, not the type of thing we would keep a kid from parent for.
given all that, they believe that the mother has met her burden to show that despite prior terminations a decade ago, she can provide a suitable, legally secure placement for the child. I see that I'm running low in time. As the first assignment of error, I would just point out that I think the most natural reading of that confusing F is that it has to apply to everything before it. I think we'd all agree it's an awkwardly written one sentence paragraph because of that. But if not, it renders the whole 50 words before it surplusage. I don't know. We'd be repeating the whole temporary custody through a 2-month period. That whole phrase is repeated twice. It's all surplusage unless that if modifies everything before it. With that, I believe I'm just about out of time. And so we would urge that this court reverse the decision below and return AM to his mother's custody.
Thank you. Any questions from the panel? Well, counsel, thank you so much for your presentation. Sorry that we had little technical issues, but appreciate it. And thank you for appearing via Zoom this morning. And we will take the matter under advisement and issue a written opinion that will be sent out to, obviously, CSB as well as you. And you can also look on our website, and we release our cases to the Supreme Court for electronically. Okay, thank you very much.